Hello, everyone. Welcome to this new episode of the CDS Talk, a new format of the Center for a Digital Society, where we have the pleasure to invite distinguished guests who present their research on a variety of topics on digital law, competition, innovation, etc. My name is Anna Ferrari, and I'm honored to be the moderator of today's CDS Talk, which is in fact the presentation of the book Artificial Intelligence and Human Rights, published by Oxford University Press. Joining us today are the editors and some authors of the book who will introduce us to this timely publication covering a wide range of global areas where AI could impact human rights. In particular, we will cover AI and the right to privacy and data protection and facial recognition technology with my CDS colleague Natalia Menendez-Gonzalez, AI and disability rights with Matilde Ceron, AI and fair trial rights with Helga Molbeck-Stensi, AI and right to health with Enrique Santamaria, AI and the right to a healthy environment with Alberto Quintavalla. And we will hear the constructive feedback on the overall discussion by Anca Radu. Some housekeeping rules before leaving the floor to the speakers. The structure of today's talk will be the following. Alberto Quintavalla will present the book, then the speakers will present for roughly 5 minutes each, the book chapters they authored, then Anca Radu, the discussant, will provide an overall feedback. Finally, we will open the floor to Q&As. To the people who are following us, first of all, thank you for being here, and you can directly ask your question in the chat during the whole presentations, and or at the end by raising your digital hand and switching on the mic. Without further ado, I leave the floor to Alberto Quintavalla, Assistant Professor at the Erasmus School of Law, University of Rotterdam.
Good afternoon, everybody, and thanks for the invitation. So I would like to basically draw a bit of the general overview of the edited book. And I would simply like to start with the introduction of the book itself, where basically we are arguing, Jeroen and I, Jeroen cannot be here today, unfortunately, but basically Jeroen and I are arguing that both early milestone of AI and human rights codification process have basically their origins at the end of the 40s. So as you may know better than me, there has been an article published on Mind, Can Machine Think, by Turing. And 2 years earlier instead, in 1948, there was the adoption of the Universal Declaration of Human Rights. And in this declaration, basically there was the recognition of inherent dignity and of equal and inalienable rights as the foundation of freedom, justice, and peace in the world. So those two phenomena have had overlapping history for something like the next 50, 60 years. However, they have hardly ever converged. They actually converged very recently, in the last 10, 20 years. And the basically discussion revolving around this interaction between human rights and artificial intelligence has always been inquiring what type of interaction does exist. So the question usually is AI, let's say, a tool that benefits human rights, or is it something that poses risk? And that's basically what we are trying to map in this editorial project. The example of something that could simply enhance human rights is with the prediction medicine and providing better care to patients, but this I will simply let Enrique discuss more in detail, or bias algorithms discriminating against ethnic minority, women, or disabilities. And again, I will let Matilde discuss this more in detail. So in terms of main findings of this editorial, let's say, endeavor is we basically develop, I would say, three main findings here. The first one is pretty trivial. So the relationship of AI and human rights is basically a web of multilateral coexisting relationships. We cannot argue that AI is positively impacting human rights solely, but at the same time, we cannot argue that AI is only negatively impacting human rights. The second finding is that the interaction is not only unidirectional or unilateral, meaning that it's not just AI impacting and affecting human rights, but it's also the other way around. Human rights can actually impact AI. And this is because human rights can be used as a standard for measuring basically the societal acceptance of AI technology and provide certain guidance and identify the barriers. And building on that, the third finding is basically that it's society who decides what to do with AI and to what extent their acceptance to risk. So from basically this framework, it's possible to identify basically certain human rights consequences. And in the book, what we are doing towards the end is to identify what type of risk and how to categorize this type of risk on AI. And here we draw, let's say, a dichotomy between structural and functional risk. When it comes to basically structural risk, those risks are arising from the nature and the design of AI itself. So they refer mostly to some epistemic concern, and they are related to the technical know-how. At the same time, functional risks instead arise mostly from the functioning of AI, and they pertain more to basically the normative concern that we may have in terms of the transformative effect of AI in our daily life. And this distinction is certainly an oversimplification, but at the same time can provide actually, let's say, good guidance on how to develop human rights norms to address those risks. Meaning that when it comes to, let's say, structural risk, those concerns can actually be addressed at a higher governance level, given that this technical risk may simply pertain to the area of know-how and may be simply common to many different jurisdictions. At the same time, the functional risk instead, they would simply be to be addressed at a lower governance level because they pertain indeed to a more normative concern, and because of that, also, let's say, the proclivity of actors of accepting risk may be more context dependent. However, basically, this is not the, let's say, final solution, the holy grail for, let's say, how to devise human rights norms to address AI risk. One must indeed acknowledge that the human rights norms have indeed certain gaps. This simply because human rights norms predate AI. At the same time, it's very difficult to account for all the action by AI. An example is, for example, the right to health of having many different, let's say, conflicts materializing at individual or a collective level. And here, from a more, let's say, human rights general perspective, the idea is that it's very likely, at least for Jeroen and I, that the role of proportionality will play a, let's say, essential role in the future when it comes to basically distinguish and solve and address these conflicts of law. And lastly, the impact of AI application spread basically unevenly, meaning that the production of AI is usually in a certain area of the world, namely Global South, and in other areas, there are individuals who are benefiting mostly from, let's say, the deployment of AI. And this phenomenon, which has been dubbed as AI colonialism, point exactly at the, let's say, related issues of, let's say, the obligation to respect and to protect human rights. Meaning that usually what we discuss in terms of human rights implementation by the state, the attention is usually geared towards our obligation to respect. So basically, to have an idea that the state should simply make sure to respect human rights when it comes to the implementation. However, when it comes to AI, this is actually not going to be the main focus of the issue, meaning that there has been some human rights violation by the use of AI, for example, the Toeslagen affair in the Netherlands. However, this is, let's say, playing up to a certain extent a secondary role, because the main issue usually is to be found in the obligation to protect. So basically, the idea that the state should ensure that other actors would, up to a certain extent, fulfill the human rights obligation. And this is basically where the main challenges have to be found. Having said that, I don't want to take too much time. I basically draw this general consideration. I may have other as well, but I could simply leave them for the discussion part. And I would simply give the floor to the, let's say, more in-depth analysis of specific human rights.
Well, thank you very much, Alberto. And then we can happily proceed to our first speaker, Natalia Menendez-Gonzalez, PhD researcher at the Law Faculty of the European University Institute and research associate at the Center for a Digital Society of the UI. Natalia, the floor is yours.
Thank you, Anna, and also thank you, Alberto and Jerome, for giving me the opportunity to contribute in this timely book. What I try to do in my chapter, it's basically an intellectual exercise, but also I hope it has some kind of practical implications. Because basically, and also we can discuss this with Anka later, when we talk about human rights, the right to human dignity is perceived as the corollary of the rest of the human rights. But what I argue in my chapter is that when we are dealing with AI technologies, instead of the right to human dignity, which is obviously very important and should be also tackled and protected, it's the rights to privacy and data protection, the ones who should be, or which should be considered the corollary of other human rights. And the main reason for this is basically because most AI applications are fed with data, and in many cases, let's think, for example, a very mainstream AI application nowadays, ChatGPT, are fed with personal data. To illustrate my point, what I do in my chapter is using the example of facial recognition technology, and more specifically, it's used in the global north. So, for example, I argue that in the case of facial recognition, obviously the right to human dignity is impacted, but it's impacted because the use of facial images is in somehow commodified, or there's also some literature that refers to the human images being used as barcodes. So human faces, instead of being a very important part of human beings that transmit a lot of things, are used only to identify or verify the identity of people. So it's a kind of ID that you have attached to your face. So in this case, this is the connection I make with the right to human dignity as far as AI technologies are concerned, but also facial recognition. I also discussed, for example, the right to security, and also the right to freedom of assembly and association. And in this case, the argument is a little bit more the same. It's because we have these technologies that we can identify people who attend demonstrations, and we can punish them. For example, governments can punish them for expressing their political opinions. And in this case, we have the very recent case before precisely the European Court of Human Rights, Gluckin versus Russia, where a citizen was, thanks to live facial recognition, identified as having conducted a protest, and after that arrested. I also tackled the rights of the child because, again, children faces, they change a lot with time. So this, let's say, impacts the accuracy of facial recognition system. So trying to use these devices with children, apart from privacy and data protection implications, is extremely risky, and also, I would say, flawed in some cases. So to sum up a little bit, what I do in my chapter, it's arguing that the rights to privacy and data protection should be understood as the corollary human rights that are affected by the use of these systems, and also that links between the rights to data protection and privacy and other rights, such as human dignity or the rights of the child, can be always traced when we are dealing with facial recognition technology specifically, but also AI technologies in general. We can discuss further in the Q&A, and thank you very much for your attention.
Thank you very much, Natalia. That was really interesting, and I'm sure there will be follow-up question later on. Okay, now we turn to Matilde Ceron, Max Weber Fellow at the Robert Schuman Center, European University Institute, who will tell us about AI and disability rights.
Thank you so much, Anna, and thank you for this opportunity to be back virtually in Florence. I've now moved on to Salzburg, actually, and it's lovely to share with you shortly our perspective on what the impact of AI can be on disability right. And I think this goes very well with what Natalia already discussed, as what we try to do is look at both the, let's say, good side of AI as an opportunity to improve the digital inclusions of persons with disability, but also, and mostly what we then identify is how some of the negative aspects that Natalia has already mentioned are even more exacerbated in the case of disability. And I will not get into much detail, but an example overall, we were discussing about the use of biometrics information. When we're talking about persons with disability, clearly these can lead to the disclosure and the identification of something that is very sensitive, which is, again, relating to their disability status. And what we try to do in the chapter is take the benchmark that is the Convention of the Rights of Persons with Disability, and look at what kind of human rights are or the construction of the multifaceted dimension of human rights that are to be protected in line with the convention. And here we can see that a very important dimension that has been highlighted by disability studies literature is that, and is very relevant in relation to AI and human rights, is that we start from a challenge which relates itself with the conception and the understanding of disability. The disability studies literature have moved on from a medical definition of disability to recognize a social dimension, which implies that we cannot only see for example, the physical status of a person as a potential barrier to their human rights, but we need to understand that the social construction around and the barriers that are then imposed by how we use technology are relevant as well. And with this, what the convention wants to do is to have an approach that is not just addressing discrimination, but wants to promote inclusive inequality. And it does so into looking in 4 dimensions, which are the redistributive, recognition, participative, and accommodating dimension. And I will not get into the details of all of them, but I'm happy to come back to this in the discussion. But what we try to do is then is looking at specific use cases that are indeed a risk to indeed having this dimension of equality fulfilled, and what kind of intervention would be needed to protect them. And then it's a very good day to talk about this, because what we also do is to address one of the regulatory initiatives that is in a way the most forward in terms of having a human-centric approach to the regulation of AI, which is the AI Act, which is having its last trilogue today. So it's moving on in a way from the analysis that we had that was based on the Commission proposal and the stakeholder contributions. But what we see is that even when we take as a reference this somewhat advanced approach to the protection of human rights in regulated technology, we still see the limits of, again, having this somewhat multi-layered concept that is that of disability itself, fully protected by the regulation. And one of the main challenges that we see, and that relates to vulnerable groups in general, is that it's quite easy to exclude specific categories that are minorities also along the process of developing a technology. So we can think about, for example, the training data that is used, but also in a way representation in terms of testing the use of technology. And this is a crucial element if we want to be able also to have these rights protected, that we cannot only consider the level of risk that the average, let's say, individual has, but we need to be able to address and have representatives of vulnerable groups involved in the development of this technology, so that their perspective can also be taken into account in the development of this technology. Again, the caveat is that we stopped at the Commission proposal, so hopefully some steps forwards have been made, and the regulation can still be much better than how we assess this in our chapter.
Thank you very much, Matilde. I was actually reading this morning in the Political Brussels playbook that there are doubts that it will be the last round of discussion. And one of the main problem is definitely banning facial recognition. There is not agreement on that. So yeah, also what Natalia was explaining us. So yeah, I guess this discussion and this book is even more timely. Okay, then we move on to our next speaker, who is Helga Molbeck-Stensing, PhD researcher at the Law Faculty of the European University Institute. And she will present us her research on AI and fair trial rights.
Yes, thank you very much. Thank you for both the opportunity to take part in the book and in this event. So my chapter is actually a co-authored chapter with my colleague Alexander Quemi, who is an AI scholar. Our starting point was the fact that by far the most common human rights violation by a lot is the right to a fair trial. Almost half of all the cases that are brought to the European Court of Human Rights have a fair trial complaint, and the court has issued judgments finding a violation on the right to a fair trial in more than 10,000 cases, which makes it extremely common. And in fact, I would say in my studies of various courts, I have yet to find a court that exists that is not overloaded and under-resourced. So there is room for improvement in what we have currently without AI. And it's also one of the places where AI has been, or AI or complex computer technology more generally, has been used almost straight away. Most famous case in this regard is probably Loomis versus Wisconsin, which was a case where a person was found guilty in a drive-by shooting case, and his sentence was in part determined by a piece of software called the Compass software. And he complained that that meant that he was not being sentenced individually, but was being sentenced as part of a group. And he complained that the software used gender as an indicator of how long your sentence should be. And an interesting thing in that case is that the court couldn't decide whether Compass used gender or not, because Compass is proprietary and that information is not actually available to the public. That being said, there are numerous works all around Europe and the world to include more AI in courts, because as already stated, there is a need. We looked at two different elements where AI might be included. One of them is ensuring a fair trial. So we know that humans are biased. We know that humans tend to become grumpy when they're hungry and difficult when their local sports team loses games and so on and so forth. So we know that humans are not perfect judges already. And the idea was there that perhaps, seeing as an AI, would not be prone to these bouts of emotions, maybe they could be a more appropriate mouth of the law. The second thing that we wanted to look into is much less studied, but is in a certain sense much more important, and it's in ensuring the right to a fair trial within a reasonable time. It's not as sexy, but the thing is that when you have so many cases at all these courts, and not a single court that I can think of who is not overloaded, you really do need to move some cases along. Otherwise, you end up in situations such as at the European Court of Human Rights, where there is now so many cases coming in every day that the court is unable to deal with them in a reasonable time. So the court that's supposed to make sure that the other courts are behaving is also not capable. The problem that we found with the existing technologies that are being used is that they don't seem to respect what it is that courts are supposed to do. So what we did in our chapter was that we tried to take the right to a fair trial as it appears in the European Convention on Human Rights and in the International Covenant on Civil and Political Rights, and make it into a framework for what it is exactly that courts are supposed to be doing, what it is exactly that a fair trial is. And we also used Dworkin in order to help shape things along a little bit. And we found three overall themes to address. One of them is that all defendants in criminal trials, but it also appears in civil trials, have a right to know what's going on. They have a right to be informed in a language that they understand if they are being accused of something, and they also have a right to an interpreter. So there is a demand of understanding. They have a right to be trialed independently and individually. So even though some trials result in sentences of several individuals, the sentencing has to be individual. You cannot be put to prison because people like you, of whatever that might mean, tend to do things in a specific way. It has to be you personally, and it has to be dependent on what you have done. And the third thing is time. So courts are charged with a specific element in time. They're charged to adjudicate on the basis of things that have already happened, on the basis of laws that were enacted before the thing that they're adjudicating happened. And one of the problems with this and the use of AI in, for example, recidivism software is that it's actually designed to try and predict the future. So if you end up using recidivism software to determine how long someone should go to prison, you're saying the likelihood that you will commit another crime in the future is indicating what punishment you should receive. And that is not really what courts are supposed to be doing. Courts are supposed to judge you on what you have already done. I'm just going to stop there, and I'm happy to take more questions, but in order to move things along and keep it brief.
Thank you so much, Elga. You took us on a path of almost a dystopian future. So maybe we will have a question later on about this. Okay, our next speaker is Enrique Santamaria, postdoctoral researcher and project coordinator at the Erasmus School of Law, University of Rotterdam. And he will talk about the right to health.
Thank you very much. Thank you for the invitation and for allowing me to be here. So I wrote a chapter about AI and the right to health. And basically what I tried to do was three things. First, map what are the current AI applications in the realm of health. Secondly, see what are the opportunities and what are the challenges associated with these applications, in connection, of course, to the right to health. And third, explore what are the contemporary policy and regulatory proposals in this realm. So starting with the applications, we can see that AI has boomed in the realm of health. So you find applications in image-intense medical specialties, radiology, for example, or oncology, for personalized treatment and precision medicine, for AI for mental health, for something called digital phenotyping, for public health, for drug discovery. So there's a lot going on. Of course, the opportunities are quite obvious. The first one would be the improvement of human health at the individual and the collective level. At the same time, the right to health has these two dimensions. So the right to health can be considered an individual right, but also a collective right. Another opportunity would be to address global inequalities, global health inequalities more specifically, to, for example, allow low and middle income countries to access certain technologies, or in the absence of, for example, physicians in certain territories, whereby internet penetration is possible. Another opportunity would be to tackle the underrepresentation of women and minorities in health research and innovation, and improve medical education and training. However, beyond these opportunities, you can also find several complicated challenges. I've kind of categorized them in four: the problem of inaccuracy, the problem of unexplainability and opacity. Of course, again, the threats to privacy in connection or that have a direct impact on the right to health, and some other, let's say, miscellaneous challenges. On the first one, inaccuracy of AI applications, here you can see the very big problem, bias. So I've encountered that bias can, of course, occur because of prejudices, previous knowledge, or experiences, but not only that, but also on how and where the data were collected. Can also occur that the data set was oversampled or undersampled. Or can also happen that there's a contextual bias, meaning that AI technologies can provide a recommendation that is not contextually applicable in a certain country, in a certain context. The second big problem is the problem of unexplainability and opacity. Again, we encounter here two big problems, the black box problem and the update problem. In the realm of health, of course, this has consequences, at least for two entitlements derived from the right to health. The first, informed consent, and the second one, the right to explanation. So the question is how a physician can obtain informed consent if he really doesn't know what's going on, and how does AI technology and that particular application works. The same goes for the right to explanation. The second big problem relating to unexplainability and opacity is the update problem. So the question here is, are we going to lock the algorithms, or are we going to allow them to run looser? Of course, there are certain trade-offs in terms of the right to health. So the looser the algorithm, and if we manage to exploit the learning capacities of the algorithm, then that can derive, of course, in more possible beneficial consequences for the right to health. But of course, you have certain problems associated with the risk of having a self-learning algorithm go loose. And finally, on the privacy issues, we have to remember that health data are sensitive data, which are object of a stricter and more protective regulation. But the question arises then what to do with secondary uses of data. That is, the data, the uses of data for which they were not originally collected. So that again can be phrased in terms of trade-offs. Are we going to allow the secondary uses of data, and for which purposes? If we are going to allow it, for example, for research, that will be beneficial for health and the right to health. But then, of course, consent can be problematic in this very same issue. We have other issues like the concentration of power and health data in the hands of a few big tech companies and the problems associated to cybersecurity. Finally, to conclude, there have been several policy and regulatory proposals. One, to tackle the update problem is not to focus on product regulation, but on a system regulation of AI medical devices, meaning that the regulator should focus not only on the product itself, but on the whole chain on which the algorithm is produced, starting from the data sets, into how the algorithm is deployed and how it's functioning and how it's being updated. On the secondary use of health data, it has been proposed the principle of solidarity should work as a standard to measure which secondary uses for trained algorithms should be allowed. This, as I said, was a very brief overview of my chapter. I look very much forward to the questions, and I thank you once again for allowing me to be here.
Thank you very much, Enrique. That's for sure a very complicated and complex topic, health. And staying on the subject on health, now we move to healthy environments with Enrico Quintavalla, Assistant Professor at the Erasmus School of Law, University of Rotterdam.
So when it comes to the chapter on the, let's say, artificial intelligence and the right to a healthy environment, what I try to do has been basically to map, indeed, the interaction between artificial intelligence applications and the environment per se. And the reason is that, at least, especially in the last few years, there has been a tendency, up to a certain extent, to define AI application as her-friendly. So there has been a momentum, again, in the past. Nowadays, let's say, this tendency has been, up to a certain extent, let's say, overcome. But in the past, there was a tendency to define AI as her-friendly. And the reason was that AI was used, for example, to optimize energy generation, predict natural disaster, helping with climate modeling, and so forth, so on. Another example could be in transport sector, the route optimization, or favoring platooning. So all these cases were showing how AI was very promising in, let's say, yielding efficiency and sustainability, or even more narrowly put it, environmental gains. However, this has only been part of the story, meaning that the chapter shows that there may be other risks associated with AI and environment. One example that the chapter is pointing at is basically the misuse of AI application. So this happens, for example, when there has been a use of AI application which was originally designed for helping or enhancing environmental protection that is used for an unintended purpose. An example here could be poachers or illegal loggers, that they use those same AI applications that have been designed to make sure that illegal poachers or loggers are simply carrying out certain type of illegal activities. Another risk that stems from the use of AI application can be the so-called rebound effect. So if we go back to the example provided earlier on the transport sector, so basically the idea of a route optimization and also platooning, the idea that all these efficiency gains may lead eventually to a more intensive usage of the very same application, favoring, let's say, further use of the transport. However, the elephant in the room when it comes to, let's say, the interaction between AI and the right to a healthy environment is certainly the energy consumption that those AI applications are basically having. And the carbon footprint of the ICT sector is pretty high. Exactly for those reasons, the chapter continues to ask to what extent the right to a healthy environment, which is nascent, by the way, can actually address those issues, and more specifically, exactly the energy consumption of the ICT sector. And the chapter, without delving too much into detail in terms of the development of this right to a healthy environment, which is a more descriptive part, the chapter argues that there are here two main challenges to be addressed if we want the right to a healthy environment be some useful tool for that. The first one is that the problem with the right to a healthy environment is that not all jurisdictions are enshrining this basically right. And the example here is the European Court of Human Rights, where previous case law show how basically there is the need for, let's say, having and offering protection on some environmental degradation only when there has been an interference with an explicitly recognized right. And the second challenge instead is what I was basically discussing earlier on from a general perspective, which is basically the applicability of this tool as right to a healthy environment on non-state actors. The problem is that, as we all know, non-state actors are not bound to human rights law per se, and therefore there are only soft law mechanisms that indeed have soft law. And the problem in nature. So the problem is exactly, and the challenge of addressing this energy consumption of the ICT sector by using a right to a healthy environment, how to make sure to avoid having a heterogeneous framework due to indeed different jurisdiction or let's say macro areas, recognizing the right to a healthy environment, and at the same time to make this right justiciable, let's say, before, let's say, against corporate actors. That's basically mostly it, if I need to summarize it very quickly.
Thank you very much, Alberto. That was a very intense but insightful overview. And talking overview, now we give the floor to Anka Radu, PhD researcher in law at the European University Institute, who will act as our precious discussant, and will try the difficult challenge of give overall feedback.
Thank you so much, Anna. Please excuse my voice. It is that time of the year. Let me start by thanking Natalia and Alberto for the kind invitation, and let me start by congratulating all of you, the authors and the editors, for their hard work and efforts in putting this book together. I think very often we take this for granted in academia, and we should not. So again, huge congratulations to all of you. Rightfully so, I think already Alberto mentioned in the introduction, the editors have highlighted from the very beginning the simultaneous codification processes of AI and modern human rights. However, only recently we have witnessed what we called an AI hype, and I believe the reason for that is the convergence with human rights, or to put it simply, is that we are witnessing many human rights violations. And with regard to this observation, I believe that we are also witnessing a shift from law governing facts to facts or violations of human rights governing the law. And I think AI applications show us that more and more. So this is why the book fills a gap in the literature by extensively covering the interplay between AI and human rights. As already mentioned, it comprises first, second, and third generation rights. And I believe this is the first attempt in literature, but also I remark the spot-on observation that, and I quote, the interdependence and the divisibility of human rights imply that effects on the one right rubs off on the other, end of quote. And this is another important contribution of the book. Then it covers, as already mentioned, both positive and adverse relations. And regarding the latter, all of the authors paid close attention to the life cycle of AI systems and clearly identify risks at every stage: design, development, and deployment. The same attention was paid also when it comes to the Human Rights Project, and almost all of the chapters addressed risks and opportunities at the various levels of the Human Rights Project: international, regional, and national. I think another contribution of the book is providing an answer to the question of whether the human rights framework is the right one to address AI-related issues, risks, and opportunities. And I will get back to what answer the book provides to this question. But going a bit on substance, I will address the chapters that were presented a bit today, and I won't summarize them because you already had that, but I will try to tell you what I think their main contributions are. So when talking about the first category rights, authors such as Alessia Dornetta and Ignacio Cofone did not only tackle with the many nuances of privacy and data protection, but they also managed to draft a roadmap for key actors. And in my view, the contribution of this chapter is to clarify the divide between the transparency principle, often evoked by legal academics and professionals, and the accuracy principle, just as often argued for by technicians such as computer scientists. And one's approach to privacy and data protection is then taken under the chapter of Natalia Menendez-Gonzalez, where she offers an interpretation of these rights in relation to facial recognition technologies. As she already underlined in her presentation, the main contribution of her chapter is arguing for a shift from dignity as the corollary of human rights to privacy and data protection having this status in the context of AI. Further, Antonella Zara, Silvia Favalli, and Matilde Ceron stress in their chapter dedicated to AI and disability rights a crucial aspect, that is the need for the element of representation, which unfortunately, at least so far, seems to be missing or to be ignored, including at the level of ongoing regulatory efforts. This relates a lot to the requirement of diversity and inclusivity that we, academics and civil society organizations, keep stressing when it comes to AI regulation.
There are some efforts, I think, in this respect at the level of the Council of Europe, but without a doubt, more needs to be done here. Then the chapter of Helga Molbeck-Stensig and Alexander Quemi on AI and the right to fair trial is very important, as I believe we are witnessing a massive deployment of AI apps in the judiciary. And I won't repeat the three main themes that Helga just mentioned, but I do invite you to check the database of the CEPEGI's Resource Center, and you will see that already there are 92 systems published in there, and another 100 are in the pipeline and are soon going to be published. So I believe this chapter contributes a lot to this discussion, and I think more and more we will see on this topic. Then the chapter on AI and the right to health, wrote by Enrique Santamaria, maps the current, as he told you, maps the current AI apps in the field of health, their opportunities and risks in relation to related human rights. And to my knowledge, this is the first effort in the literature. And lastly, Alberto's chapter on AI and the right to healthy environment. I think it goes without saying that the environment has become, or at least should become, a prerequisite for the enjoyment of all other human rights. Therefore, I believe this chapter too brings an incredibly valuable contribution. To conclude, I think the book contributes by looking, as I told you, at various levels of the human rights project, international, regional, and national. And we need to deal with all of these stages to better understand the interplay between AI and human rights. And it concludes with three ideas: that there are just as many opportunities as there are risks, and we need to understand how to put forward and to ensure the enjoyment of human rights and still develop technology. And it also stresses that it is still all up for grabs. As you told in the beginning, we are currently waiting for the final drafts of the AI regulation at the level of EU and at the level of the Council of Europe. So once we have that, I think more work needs to be done in academia. And lastly, in my view, a crucial contribution of the book is that it states that the Human Rights Project is the right framework to deal with AI-related issues and risks. The book represents a strong foundation, and it invites to conversation academics and legal professionals all together as we are figuring out how to further incorporate technological developments, but at the same time trying to answer what we call the question zero, how we would like the world of tomorrow to look like. And without a doubt, understanding and clarifying further the interplay between AI and human rights projects is crucial in order to ensure opportunities of AI and mitigate related risks. This is all from me for now. Thank you so much.
Thank you so much, Anka. That was so beautifully summarized. So we're all thankful to you for this brilliant summary. Okay, now we can open the floor for questions. I can monitor the chat, but also please feel free to raise your digital hand or switch on your camera and switch on your mic and intervene directly. So I see Alexandra Karaiscu. Yes, please.
Yes, do you hear me well? Okay, great. Thank you very much for these very interesting presentations. The book sounds amazing. I haven't had the opportunity to read it yet, but I'm sure I will dig into it the moment this event finishes. I would just like to ask two very brief questions to some authors. The first is directed at Natalia Menendez Gonzalez, who spoke about facial recognition technology. And I would like to have a clarification if possible. I believe at a certain point in her presentation, you mentioned that the right to privacy and data protection are the primary rights that are affected by the use of AI, and that other rights, such as the right to human dignity or the rights of the child, are affected in a way indirectly through the right to privacy and data protection. So my question would be, do you think that other rights, apart from the right to data protection and privacy, are only indirectly impacted by the use of AI? And what would that mean in terms of conceptualizing the legal implications of the use of AI for these rights? Especially, I'm a researcher in the field of AI and discrimination and the conceptual difference between direct and indirect discrimination. So understanding AI as impacting other rights only indirectly, if I have not misunderstood that claim, would have legal implications per se. And the second question is directed at Helga, who spoke about fair trial rights and artificial intelligence. And although I agree very much with her analysis, I just want to play the devil's advocate, if possible, and try to push the argument a little bit further. And at a certain point, I believe she mentioned that the right to a fair trial guarantees that any person should be judged and their punishment decided only on the basis of their own individual conduct, and not in consideration of what similar others have done. So, however, we can all agree to some extent that judges, when they calculate the punishment for a defendant, they are most often influenced by their experiences with previous convicted persons or with previous similar crimes, besides their emotional state and whether it's a good weather, they're hungry, their favorite team has lost their game, whatever. The qualitative difference or paradigm shift in the transition between fully human judgments and semi-automated human judgment is, and again, what would be the legal implications of that? Thank you very much. Apologies for the very long questions.
Thank you, Alex, for the question. It's very nice seeing you here. So maybe I explain myself wrong, but what I argue is not that other rights are indirectly affected, is that we can almost always, I mean, obviously it depends on the case. There might be cases where they are only indirectly affected. But what I argue is most that we can almost always trace a link, even if there's another right directly affected, for example, the rights of children, there's almost always a link with the rights to data protection and privacy. So this brought me to think, usually we take, again, human dignity as this corollary. In the case of AI systems, because data is so much important component of AI systems, shouldn't be the rights to data protection and privacy the ones who act as a main right, as a corollary, even when we see situations where we have, it's not that we only have a feeling, but we see there's a rights violation here, but there's not a proper right that we can say this situation perfectly fits here. Maybe the rights to privacy and data protection will give us like a road to trace this human rights violation. But obviously there are many cases with other rights. Also, obviously discrimination is one of the main ones, are both directly and indirectly affected.
Yes. So you actually cut out a little bit right when you were asking your question. So just see if I got it exactly right. Is it true that you are talking about how human judges are also impacted by their own internal biases, and then you asked about the middle ground between full human and full AI? Is that more or less right?
Not the middle ground, but what do you think is the qualitative difference from fully human judgments to semi-automated human judgments?
So, the paper that we wrote, it deals with like it absolutely takes into account that human judges are biased by themselves, and we go into some of the literature that uncovers various and problematic correlations between the way judges judge and not. There is an interesting project at the Hertie School on AI and asylum rights, and the truth is that human asylum judges are very different in how much asylum they grant, also in cases that are alike, and that's obviously a problem. Now, nobody that I have seen is actually suggesting going full AI. And the AI Act at the EU level, of course, mentions that the right to a fair trial or the justice system in general is one of the high-risk situations where it cannot go full AI. So we don't even really have to consider that. We don't have to go into that particular dystopia. But we do see, as Anka stated, that it's happening. The AI is being employed, and the main concept that we wanted to further was that when you apply AI to court systems, which is not only going to happen, but which is also probably a good thing, at least in some cases, because there is a need to speed up trials, and there is a need to make them more efficient, and there is also a need to address this problem of bias that we know that we have. And AI might potentially be a way to alleviate that in some cases. But if we are to do it, it's absolutely essential that we first decide what it is that we think that the court is supposed to be doing. Because if we just train the system on what the court usually does, we're obviously going to see the same biases. And even worse, if we train the AI on something completely different, we're not going to reach the solutions that we think we have. And again, taking the example of the recidivism software, the software is designed to determine the recidivism risk. And that's a different type of decision than deciding how much and how long someone should be in prison. Because recidivism really is about the future, whereas the sentence length, the initial sentence, is about the past. So that's kind of the main point that we wanted to make.
Okay, great. Thank you. Then I can take maybe a question from the chat. One from, I see it from Mohammadi Ali, and then come to Farzad. So Mohammadi Ali asked, can you mention again, what is the relation between AI and human rights? Who wants to take this question?
Yeah, I mean, I can address these questions very quickly in the sense that, yeah, what's the relationship? I would simply say it depends. The question is, it depends. It depends on the relationship that the specific context, let's say, from the specific context. It doesn't only depend on the, let's say, relationship between a specific human right and an AI application, but also on how that AI application has been used in a specific context. If I have to go back to the, let's say, discussion on the right to health environment, as I mentioned, basically the AI application used to identify illegal loggers or poachers can actually enhance environmental protection at the same time. If this has been used by, let's say, the very same people being illegal loggers or poachers, then let's say the relationship is straight away reversed. So I would say there's no actual answer on that. The only answer is that there is a web of multilateral and complex relationships. That's what I would simply say. Then I leave the floor to the other authors if they want to add anything, but I don't know.
Okay, I think Alberto, your answer was already quite comprehensive. And then maybe we can pick Farzad's questions. Farzad, if you feel like switching on your mic.
Yes, thank you so much. Thank you everyone for this amazing debate. I really enjoyed and learned a lot. My name is Farzad. I'm an Iranian human rights defender and political activist. Studied human rights in Bologna University. And I want to ask you a specific question. I mean, about a specific thing happened recently, which is like a new debate in the context of human rights in Iran. Well, after the Mahsa Amini and Women Life Freedom movement, the civil society have moved on significantly. Like the state, the regime did a lot of movements, did a lot of actions in order to mitigate like non-hijab movements coming from civil society, but almost all of them were failed due to the high enthusiasm, high levels of activism in the civil society. But about 3 days ago, something happened that the new questions are arised. And the reason I attended to this seminar was actually to know about this. And that's in a city in northeast Iran, the name Mashhad. In one of the metro stations, the regime started to use facial recognition cameras with the women, with the girls who didn't have the proper hijab, could see their ID card with the name, with all the the birth dates, like real personal data on a big scoreboard in the metro station. This is very new and horrifying for us as civil society, as human rights defender in Iran. And when we are talking about human rights in Iran, there is not a legal system which you can mitigate these violations. So my question would be, is there any way, in your opinion, which can mitigate this abuse of AI when it comes to human rights in the context of Middle East in general, countries like Iran? Because it's not only my question. I'm asking this question as a member of a civil society of Iran. It's a very viral question in the social media of Iran. I mean, it's like no political activist is ready for this. And what happened in Mashhad was only a test. Of course, the regime hasn't started the viral use of it, but it was an alert. Yeah, thank you so much, and I'm very keen to listen to your answers. Thank you again.
Yeah, maybe I can take at least on the facial recognition part, because I've been reading not a lot, so I might not be properly fully informed, but I've been reading a little bit about the use of, especially about the use of facial recognition technology to monitor whether women or girls or young women were wearing in general Islamic veils, which is also something I'm not mentioning or I'm not tackling in this chapter, but I'm also working on for another publication, which is precisely because another human right that typically people might not think, let's say the first one when we talk about human rights impacted by AI, for example, I think privacy, data protection, discrimination, or fair trial are maybe the three that are most popular or most quoted, but it's precisely freedom of religion, believing in any sort, I would say. And this is also deeply problematic. Facial recognition systems are used to profiling people, for example, based also on religion basis, because also I know in other countries, just by identifying people wearing different kinds of religious veils, you can discern the religion that these people practices, which is also sensitive data. So again, it might not be the first thing people start to, but the use of facial recognition, it's also deeply concerning regarding this. Also, I wanted to add, you said these tests in this city were only tests and the data might be deleted, but I would say be careful with tests. There's a very good piece by a colleague of mine, Catherine Jasram from KU Leuven, about the use of facial recognition pilot programs. I think it's only targeted to Europe, this piece, but in general, because the data collected and processed by those tests, trials, it's not always deleted, it's not always properly used, it's not always, let's say, properly managed. So even when people might relax because they say, no, they are just tests, it's just if things do not go okay, there's no fear that these systems will be used, be careful. Yeah, and I would extend this to all AI systems. Tests, not necessarily, but might not always be harmless. And regarding the mitigation, I would say it's extremely complicated. I would like to hear my other colleagues, and maybe Anka, if you feel like it, because you have been working as a human rights lawyer, so maybe you have something to say at this, but I would say it's extremely difficult. And in this case, AI systems might not is the thing, because it's very difficult to trace, for example, what happens with the data use, or what those systems, whether they are repurposed. Maybe they install those. I'm not saying this is the case, but sometimes, for example, we said it during COVID, they install facial recognition systems to monitor compliance with quarantine rules, but in Russia, those systems after were repurposed to monitor people on public transport systems in general. So it's very, very complicated. And in this case, I think AI, it's a little bit sneaky. So we need to be attentive. This is what I can say at this point. But hopefully there will be more research on this and more action, because it needs to be taken.
Thank you so much. Thank you very much.
Maybe if I may, I don't know if it is as usual, but I have a follow-up question to Farzad on your question. Because you're an activist, maybe you can share if you actually have any recommendation on how to avoid, if you are thinking how to avoid being recognized during like protests or occasion of expression, like freedom of expression occasions.
Sure. Well, when we are talking about Iran, the context is very particular and different about activism. The recent movement had distinct differences with the last movement. In the contemporary history, every decade, almost on average, we see a huge movement, starting from 2009, the Green Movement, after presidential election. And again, 2019, what happened that it was very, very shocking for not only me as an Iranian, but also for a lot of colleagues of mine, that the internet system was down in Iran for 1 week. I mean, that's a huge thing, and it was not very viral in the news, because I think, I'm not saying it as an Iranian, as an activist in general, I think it was a big news that a country shut down, I mean, the state shut down internet for 1 week, and the connection was lost, and there was a massacre happening in Iran, and with the COVID starting, it was more out of news, let's say. But the recent movement, well, civil society, particularly women, are a huge part of it, and the state, from after the turmoil, when the huge protests were kind of mitigated, so the regime started the threatening, like there are these cameras in the highways, those cameras which you might have a fine by passing the red line, whatever. Those cameras were being used to control the hijab within the car, inside the car, because already hijab inside the car was a huge debate in religious parts of the state, whether it's a private part within the car or it's still a part of society. It's very technical, I'm not going to go within it, but those cameras had huge errors. Just a funny example, one of my cousins had a fine. My cousin is a 45-year-old man, and had a fine of not having a proper hijab in one of the highways. These examples were showing the huge errors, but well, what we were guessing was that they were just threats. They were just random threats of showing the control, but there were rumors of acquisition of these facial recognition cameras from China, and no one was sure. There are still rumors. There is no fact to prove that. But what happened in Mashhad 3 days ago is showing that those rumors might be true. Maybe not necessarily from China, but these facial recognition cameras are now on the hand of the state. And before, there were like some hijab ban. Hijab ban is a Farsi word meaning the protector of hijab, the members of the states who were standing in the certain places, controlling the hijab, like human to human interactions. And there were ways, it's a long debate, I'm not gonna take your time, but there were always something to think about in advance. Well, if the regime gonna do that, people gonna do that. If, like, you know what I mean? We always could predict the next step. This is the place, this is the time, this is the moment that we have no idea, because we are talking about a super powerful tool. I mean, these cameras can identify all your data, and the state can know everything about you. I mean, the level of hijab, and the level of hijab can be defined by the regime. It's not only 0, 1, with hijab, without hijab. I mean, the levels can be precisely defined. So to finish it, the answer of me to your question is that I don't know, and I'm very sorry of that. And yeah, I hope that there will be not necessarily a solution. I mean, an interaction and an action and reaction to this move from the state of Iran. Thank you. Sorry for talking too much. I hope I was clear.
Well, thank you very much for that. I think this was really interesting, and I wish you all the best in your fight for human freedom, really. We have another question in the chat. Tinaka Milaki asks, okay, in the AI Act proposal, AI systems classification with regards to risk is connected to the risk an AI system poses to fundamental human rights. And in case of a minimal risk AI system, the transparency requirement should be fulfilled. So do you think that in that case, requirements such as robustness, safety, environmental well-being, etc., are not important enough on terms of AI Act proposals?
So I'm not entirely certain I understand the question entirely, but I think like if we talk about the AI Act a little more generally, one of the potential issues is that this technology is moving very, very fast. So what the themes that are considered low risk right now might turn out to be high risk in the future if a technology is advanced in a way that we cannot predict. So that's one concern is how rigid this categorization is going to end up being. At the moment, it doesn't seem all that rigid, which has its own set of problems. But that's one thing. Another thing is that the thing about transparency. So if we get into that in our article, one of the problems about transparency is that it comes in at least two forms. So one of them is like objective transparency. Is there access to the code? Is there access to the training data, and so on and so forth? And the other problem is more subjective transparency. Do the people who need to understand it understand what's going on? Because, for example, in a situation of a fair trial, if you do not understand as a defendant or as an actor within this, or as a judge, of course, what it is that the decision support system you are using is doing, then it doesn't matter if it's objectively possible to know if you have a degree in computing and engineering. So I think that one of the things that the AI Act is attempting to do with all these sandboxes, and there's going to be a handbook on incorporating these sorts of things, is trying to make that vagueness a little more precise. But it's going to be very, very difficult to do. It's going to be very, very difficult to have this this regulation in place, and to predict exactly how it's going to work. Yeah.
Thank you very much, Helga. I don't see any more questions, so maybe since we have still a little bit of time, I will take the opportunity to ask my own question to you all. I was just wondering, because you're studying all the legal and innovation implication of technology and AI, I was just curious to ask you, Do you ever get the opportunity to try out these technologies that you're trying to assess, like whose risks you're trying to assess? Just as a curiosity, is it part of your work, or would you wish this becomes part of your work? Yeah, just out of curiosity, especially like AI and virtual reality, or technologies like that. Would you help your work, do you think?
I mean, I can take, in my case, I had the opportunity to, let's say, be subjective to some facial recognition technology systems. I think it was very interesting also because, for example, what the literature was saying and claiming was not exactly what I saw when I had the opportunity to interact with the system, for example, regarding the state of the art or the processing of the data. So I said in my case it was interesting also hearing to some use cases, let's say, on the other side, because, for example, I was told about the case of a autistic girl who got missing in a shopping mall in Spain, in Madrid, a very big one, who was found thanks to facial recognition. And this is something that also I try to keep in mind when I do my research, that even though when I tend to be very fundamental rights protection cautious, so in case of doubt, no deployment of the technology and these kind of things, I also sometimes remind myself of these kind of examples, because the reason why what I argue is that the reason why these technologies were invented or created, at least at the beginning, was not to do wrong to humanity. Nobody, in principle, nobody wants to do wrong to humanity. The problem is that then when you use them, obviously, a lot of issues arise, and there is where regulation and our work as academics plays their part. But in my case, I have to say it was very interesting to have the opportunity to deal with these technologies.
Thank you very much, Natalia. I see we receive one more question in the chat from Ivan Romashenko. What do you think about the role of AI in terms of human rights of legal entities, legal persons? Does the use of AI have any implication for the exercise of human rights by legal entities, legal persons?
In terms of fair trial rights, of course, the situation for legal persons will be similar to that of natural persons. But I think that's probably not the thing you were asking about. Maybe it would be more interesting to hear from some of the others.
I also don't know what the consequences would be in case legal persons have human rights. But allow me to go a bit beyond your question and also question about the role, the impact of AI on non-natural legal persons, for example, nature or the environment. So beyond the human rights framework, we can think of the impact of AI, for example, in terms of data consumption, energy consumption, sustainability. How would this impact entities that are not natural or legal persons? But specific to your question, I think I don't dare to put forward an answer.
Yes, thank you very much. I see Anka has her raised hand.
If there are no other questions, I can absolutely jump in, because I had a set of questions of my own for the authors prepared. So maybe I can challenge a bit further the research. So I will actually address them all very quickly, but it can also just be, you don't have to answer if you don't want to, it can just be something you can think of later. So Natalia, if privacy requirements were to be respected in the use of facial recognition technology, can we still talk about the shift that you were arguing for, or not? Alberto, I was thinking about this example about a right to a healthy environment, about Toyota's building this new smart city. I was thinking, like, is this something that we desire? Like, are we, sort of like slowly moving towards mass surveillance, because I think this is an example that we need to talk about when we talk about right to a healthy environment, and we see private companies being, more and more attracted to this idea. Enrique, what about the right to mental health? Can we talk about such a new right in the context of AI? Like, should people not just be informed that they are dealing with an AI system, but should they be informed of like potential effects on how their behavior and even like mental state could be affected by dealing with certain applications? Matilde, how can we ensure in practice representation? Did you think about this? Can it be done at a level of AI regulation, for example? And Helga, I was thinking about this, what I actually called it the right to an individual judgment. So I framed it a bit different in my research, but I think we're saying the exact same thing. And I was wondering lately if this should be taken in conjunction with the principle of non-discrimination. Because yes, absolutely, everyone has, I think I agree with you, everyone has the right to an individual judgment, but at the same time, we expect people in analogous or relevantly similar situations to be treated similarly, and just as much people in relevantly different situations to be treated differently. So can it be connected or not? I don't know, it's a question, so I'm just also provoking you. Thank you so much.
And for me, I would love to have an answer for you, but I've been thinking about it myself, and I'm still not sure, because there is this this conundrum between the like cases must be treated alike, and also you must be treated individually. Would love to have a debate more about it. So let's meet up soon. But I think in terms of like that doesn't even really, you don't even really need to include AI in that discussion. That discussion is something that goes on in courts in general, right? And I would say that if we want to take on the AI element of that, we could say that what might be advocated is that AI that extends the abilities of the court, of the judge. So that's why we used Ronald Dworkin, because Dworkin has this theory about the perfect judge, the Judge Hercules who knows everything, who can remember all the cases and all the principles, and who never gets hungry and never gets tired, and thinks equally good or ill about everybody. So he doesn't discriminate. There is this notion that the AI could help the human judge become more like Hercules, even if not to become him entirely. Because AIs are extremely good at reading cases, for example. They can find relevant cases for you to read very, very fast in a way that you would otherwise only be able to do if you had like an army of research assistants. And they are also better at estimating probabilities than most humans are. And most humans look at things and they think of them as either 50-50 or almost certain and almost uncertain. And the truth is, of course, that probabilities are more complex than that. So I think in that sense, if we want to improve the human, we might help with AI, but it doesn't solve a lot of our foundational problems about what it is a fair trial is. So I think that's my answer to your question at the moment, but let's keep working on it. Yeah.
Well, if I may continue, and I will not take too much time, but indeed, Smart City is actually a very interesting, let's say, forum where to discuss all these different, let's say, possible clashes among the human rights. The thing is, the actual question is to, let's say, the extent to which we would envision and aim for a fully fledged smart city, meaning that there may be different, let's say, level of smartness in a city, and therefore let's say the way to reap all these environmental gains would be to have a fully fledged city. But as you mentioned, indeed, the problem is the possible violation of other conflicting human rights, data protection, privacy, mass surveillance, and so forth, so on. And that's also the reason why at the beginning of this event, I was basically pointing at the role that proportionality may have. And again, if we have a look very quickly at the EU legislation on smart cities, we could see indeed that the EU is basically having a more hands-off approach in a way, as far as I'm concerned, meaning that indeed it basically leaves the choice to member states and to specific municipal developments on how to go forward by laying, however, a very basic principle on the matter. That's mostly it. And then if I just can add, I saw a question from the audience in the chat regarding the right to education as a basic human right. Basically, this question would be very interesting for me as well, because this identifies one of the of the many gaps of the editorial project, meaning that we don't have an expert on right to education, and that's indeed what we hope to have in the next edition. So I cannot actually answer to this question, but that's mostly it from my side. I leave the word to the other authors.
Yeah, maybe me. Yeah. So as regards with your question, yeah, the beauty of the right to health is that it encompasses 3 dimensions. So the physical well-being, the mental well-being as well, mental health, but also its relational, its social dimension. So when I speak about the right to health, I speak about all these 3 different aspects of it. And that includes the right to informed consent, also qua the consequences for the mental well-being of the person through the use of AI. There's a lot going on in terms of applications of AI for well-being and mental health. I think some of it is how to say it politely, realistic. For example, this whole trend into detecting emotions presents several problems from different perspectives, but there is a well-defined trend in the applications that's really targeting the AI well-being. So like health well-being, mental health well-being. So yeah, I hope that answers your question.
I'm gonna jump in also very briefly. I sadly also don't necessarily have a solution to the problem of representation. Something that we did beyond this chapter with Antonella Zara, we have tried to look at the representation of vulnerable groups more in general, so also from a perspective of gender and race. I myself am someone that works quite a lot at this moment on gender equality. And we see this as something that is not specific to persons with disability, but there is a problem of underrepresentation in general that we can see throughout the policymaking process. And we see it also, for example, if we look at the participation to the consultation of stakeholders, we do have the positions of sometimes also the advocates for disability rights and so on, that make their way into, for example, this summary of the consultation in a way that it actually misrepresent their position. And maybe it's also a question of expertise that may be lacking, but the challenge is throughout the board on how to make sure that especially vulnerable groups and underrepresented groups are probably overrepresented in some of these consultation processes, and are particularly targeted in the sense of making sure that the voices are heard. And this could be potentially also something that, again, I'm a political scientist, so I don't necessarily am in the position of addressing the legal aspects of some of these concerns, but there could be an attention of, for example, in terms of testing of edge cases, and making sure that some technology is not just addressed on the average population, but actually on those populations that are most at risk. And so this could somewhat mitigate the underrepresentation by somehow overrepresenting in specific situation these perspectives.
And I would say very briefly, Anka, that you got me. I don't have an answer for your question. I suspect the link with privacy and data protection will persist, but I need to think deeper into that, maybe for the next edition of the of the book. I don't know.
Okay. Thank you, everyone. Just double check when I see 2 more questions in the chat, but we're also at the end of our time. So I want to check with you. Would you like to continue for like 5 more minutes, or if you need to run away immediately? Okay, it seems like it's fine. Okay, very quickly, Sato asked about the UNESCO's ethics of AI and its effectiveness. This UNESCO principle was adopted by all 193 UN member states by November 2021, and it's recognized as a global standard. While the principle is great, to what extent could it be effective in defending human rights? Anyway, okay.
So with this, you're sort of returning to the problem that Barsad also mentioned, that there are all these different elements of human rights that are human rights in practice, in situations where there might not be a law at all. There's human rights law, which is very limited, and there's all this soft law, which has a role to play, but which is not the same as in practice or legally. I would say that it's a much broader question than one related to AI. And I would say that my assumption in the EU space is that principles such as these ones will have an impact on the legislation that is being developed, but it's not going to have an impact directly on what AI developers are going to do, because they're also in the business of making, well, a business, and having more ties than other developers that you don't actually need to take into account is going to make you less competitive.
Thank you very much, Helga. Then there is one last question from Rutel, who thank you very much for your contribution and attempts to a geopolitical issue, I think. I will read. As I've noticed, unlike what is observed in the literature analyzing EU attitudes and policies, there is almost no discussion of the potential threats of AI to human rights in the US. Instead, the main focus here is on the fact that US must dominate in the field of AI, win in AI competition against China, etc. Do you think this difference in attitudes and policies might cause friction and tension in EU-US relationship in the future?
Yeah, I mean, I may simply offer my own viewpoint on the matter with, let's say, more negative comment and a more positive one in terms of, let's say, approach on human rights and AI from the US perspective. So I would simply say, yes, the thing is, in the US perspective, is always up to a certain extent focused on the, let's say, civil and political rights, so the fourth generation right. And that's why basically there is largely no discussion or very limited discussion on the other rights. So also like the frequency with which the human rights are invoked in the US or discussed in terms of human rights is more limited. And this is, let's say, the negative side, I would say. But the positive side is that from, let's say, the approach in the edited book, and that's one of the things we didn't discuss, and I didn't mention either, the idea that actually the main threats stemming from the AI application are actually generating usually from civil and political rights. And when it comes to, let's say, socioeconomic one, certainly there are also risks coming from them, but they are most of the time intertwined and linked with a violation of another civil and political right. Moreover, what I have been hearing is that the current US approach on human rights and AI is going to be shaped relatively similarly to the EU AI Act. So let's say that we could, up to a certain extent, witness a sort of Brussels effect. That's basically what I would answer, but that's my own view.
Well, thank you very much. Then I don't see any more questions. So we're reaching the conclusion of this very, very interesting CDS talk. So thank you to all the speakers really for their contribution. And also thank you to the participants who followed us up until here and also earlier. I put in the chat a little bit, a small reminder about our next CDS talk, if you want to register, as well as up in the chat, you can find the link to the book. I know we're getting ahead of us talking about the next edition, which is great, but please have a look to this shiny new one. Yes, if there are no more questions, I will maybe leave the floor again to either Natalia or Alberto if they have any conclusive remarks. Otherwise, thank you once again and have a nice afternoon.
No, just thank you, everybody. And I think the debate we had today is just another confirmation of how the debate on this topic should be encouraged and further discussed. So for this, let's wait for new research to come, I would say.
Yeah, the same, very much. Thank you for the organization, and this is a very interesting talk, and I would say simply to be continued.
Thank you for all the questions, and thank you especially to Anka, who never fails to make things difficult for us in the best possible way.
Thank you so much for having me. It was really a pleasure, and congrats once again to all of you.
Okay, great. Then I think we can conclude. Thank you very much once again. Bye. See you on the 17th of January if you want to join us again. Bye. Have a nice afternoon.